hear how it happens. How are they going to close over that defect?
It's already been done.
What's been done?
It was done on July. It was already done, and it was sent to opposing counsel, and he did not send it.
What was done?
The conveyance back to Showcase. Showcase, as it stands, Showcase has title to this property.
Jesus, are you kidding me?
What?
You've already conveyed it.
The quitclaim deed is attached to our response as Exhibit C.
Yeah, but did that get filed with the registered deed?
And recorded.
Okay, so
by the 24th.
And it was recorded on the last day of redemption.
But we could have closed.
Again, Your Honor, their mistake shouldn't be my client's.
Oh, I have to disagree with that because under due diligence,
it's not our obligation to.
Showcase Investments versus Jorge Berlanga.
Good morning. Good morning, Your Honor.
I don't know. See you guys show up. It may not be a good one.
Well, let's hope it's a good one.
Okay, all right.
Just hope it.
Good morning, Your Honor. Melvin Babby on behalf of the defendant, Berlanga.
All right. And where are we on this?
Your Honor, our motion still stands. We're seeking to set aside the default.
All right. Response.
Well, the motion fails cause, let alone good cause, why the defendant didn't take any action against the judgment for 90 days or participate in the case. There was personal service, Your Honor. There was even a courtesy copy to defense counsel. And after entry of the judgment, email exchange. So there was actual knowledge of this hearing, and yet no action taken, and also no explanation, excuse, reason, or otherwise. So it fails under 2603, failure to state cause. Also, Your Honor, there's really no defense to this case. There's a title discrepancy that was raised, a prior action that was raised. The prior actions in the past, it was settled. I wasn't even involved. That has nothing to do with this case. There was a balloon payment that was part of that settlement that was missed. Parties acknowledge that. And a title discrepancy that was raised. However, it wasn't raised until the 11th hour on July 20th. And then by July 22nd, a quitclaim deed was drafted and ready to be conveyed, which actually has been signed and notarized and recorded as of, was signed on July 23rd. So that affects the conveyance and recorded on the 24th. And all of this is all public record, where the parties have been engaged as a landlord-tenant relationship that morphed into a land contract vendor-vendee. You have a clear vendor with a contract that had a balloon payment, a judgment that was entered by default.
I mean, interrupt you, counsel, but are you indicating that there was actual notice of the April 24th hearing given to counsel?
There was, yes, a courtesy copy. Before I served defendant, I asked defense counsel if he would accept service and emailed him a copy of the summons and complaint in the land contract. And when I didn't get a response and having the hearing coming up, summary proceedings, I sent a process server out to serve the defendant and had personal service on the defendant. So yes, there was knowledge of it.
What about that?
Thank you, Your Honor. This matter, at all times, my client intended on redeeming the forfeiture. So my client didn't participate in the forfeiture action because it didn't have an issue with redeeming or challenging the forfeiture. This matter is before you, Your Honor, because at the time my client sought to redeem the property, it turned out that the party that proceeded before you, Showcase, did not have authority to enter into the land contract, did not have authority to initiate the proceeding, did not have authority to obtain the judgment it obtained. And when this title issue was brought forth to...
Saying they didn't have the authority, what do you mean by that?
I mean, Showcase was not the owner of the property.
Who was the owner of the property?
The owners were two individuals, the last name of Mehta and Gotcher, on recorded deed. So they didn't have authority to present to this court the ability to seek forfeiture. Now, Your Honor, we didn't know that at the time they initiated the forfeiture action. Otherwise, we would have prosecuted it. We brought this before you because at the time we sought to redeem the property, the lender participating in the redemption declined to fund the loan because they said Showcase doesn't own the property.
Okay.
Declined the loan. Now, my client has this.
Who owns the property?
So what he's referring to is a conveyance to the two owners of Showcase. And
There's a conveyance by who?
by Showcase Investments, LLC, the land contract vendor, to the two principal 50/50 owners of Showcase Investments. And
When did that occur?
that it goes back to before I was involved, back when Mr. Babby was involved in
Prior to me being involved as well, 2021, I believe.
So then how is this brought in the name of Showcase?
Showcase Investments is the land contract vendor on the contract. And had this been raised,
Yeah, but hold on a second. It seems to me then, that was part of my confusion here. It seems to me that these two individuals, if one agrees that there was this conveyance, they took subject to that land contract. But they're the owners of the premises. And so I don't think Showcase can't, while their name might be on the land contract, Showcase can't bring in action because they don't own it. They don't have any interest, is what I'm hearing.
well, had this been raised, it would have been conveyed back to Showcase as quickly as it was when it was raised on July 20th. They had an ability to convey, Your Honor. They've shown an ability to convey. And this was raised in circuit court action, TRO. It was found that there is this ability to convey. Now, why wasn't a title search done? And this email that's attached where the lender raises this discrepancy, there's redactions, there's other issues with this matter. There's more to it, Your Honor. The land contract is from years ago. The balloon payment was due at the end of 2025, and this through due diligence, this could have been raised so that we weren't prejudiced at the eve of the expiration of redemption.
Yeah, and Your Honor,
But paragraph 2 on the complaint that was filed in this case isn't true, right? So when this action's brought, what is Showcase's position vis-a-vis the property? They don't have any.
They don't have an interest in
the property nor the contract, quite frankly.
but they could show an ability to have conveyed it back. And we would be
They could show an ability to have what?
conveyed it back because it went to their owners.
At the transaction, and some of this may be, I won't say form over substance. I mean, there's a reason why certain things have to be done a certain way. But the correct statement in paragraph 2, well, no, because I don't know how Showcase, I'm going to have to agree, I don't know how Showcase brings this action. That's kind of where I'm stuck.
My client brings to my attention that there is a management agreement between Showcase and the owners, so they have the ability to manage the property.
Who has the ability to manage?
Well, Your Honor, let me hear.
No, I mean, if there's okay. Go ahead.
My dilemma here is that this could have been raised on April 10th. This could have been raised 3 years ago, but defendant waits until the 90th day to bring this to the court's attention without stating any good cause. And I would submit to the court, this was an innocent mistake with an intention to convey back. what I'm being told upon information and belief from my client, without any intention, and there was no specific allegations of fraud to grant relief from judgment.
I'm not even, I get that. That's the furthest thing from my mind, because I don't believe that anybody was trying to pull the wool over anybody's eyes. Anybody was trying to do any of that. I have a complaint that lists Showcase as the plaintiff. Now, with the management agreement, I don't know what that says. There might be a way that one could deal with that. Maybe. I don't know. But then the problem is paragraph 2, which indicates that Showcase is the seller.
And Your Honor, if I may, this issue, if set aside, does not prejudice the plaintiff to the effect of refiling and having another 90 days to get paid. On the opposite end, my client's prejudiced by having invested over $105,000 into this property, his family's home, that he's at risk of losing because of their mistake.
May I address the paragraph 2 briefly? Under the land contract, Showcase was the vendor, and on the information available at the time of filing and the contract that's attached, it was the vendor. And in response to defense counsel,
correct. I'm not disagreeing with any of that. At the time that all of that was entered, what I'm saying is, at the time of the filing of the complaint, 2 individuals owned it and were really the assignees of the seller.
and also the principals, owners, 50-50 owners of the seller.
I hear you. I'm not, none of that am I disputing. I run into this with LLCs all the time.
To talk about prejudice, to sit on your hands for 90 days and raise this when this was a public record that could have been determined. And I still haven't seen a title search. The email that purports to be this defense so that the loan couldn't close because of this, Your Honor, it has redactions and other issues. The plaintiff can show that it was ready, willing, and able to close. And if we have to refile, and that's the court's decision, I'm fully respectful, but I just, in closing, would say that there's been no explanation why we're sitting on this for 90 days. And that's the prejudice without any payment since December of 2025. And now we're in this impasse where I'm sure Mr. Berlanga would like to get his loan, but if he doesn't, are we just kicking the can?
So why am I here at this point?
Your Honor, at the time we obtained financing and we're seeking to close, we obtained a title report. We obtained the liens that needed to be paid off, which were liens owned by the principals, Meta and Gotcher. It wasn't our obligation to go do a title search at the day of. We relied on their representations in the land contract. We assumed at all times Showcase was the proper party.
Here?
Because my client's going to lose his home because he was unable to redeem due to the mistake by plaintiff. And in other words, my client would have redeemed the property. My client is still seeking to redeem the property, but at this time the redemptions technically expired because it was obtained by an entity that had no authority to initiate the proceedings.
Let's guess this, just plain and simple. Are your clients willing to let them redeem the property?
Absolutely. We just don't. We've been sitting on this. We were ready.
That's not true, Your Honor. Your Honor, we asked for a 30-day extension because of their mistake, and they told us no. And we said, this is reasonable. It's your mistake. Give us 30 more days so we can go back and correct the issue with the lender. And they told us, no, we're pursuing to obtain possession. So again, my client's going to be significantly prejudiced.
I'm just asking. Your client wants to redeem the property.
Absolutely.
And basically pay off the land contract.
Absolutely.
Your client wants the terms of the land contract fulfilled, the payment, and then transfer of the property, or no?
Yes, but that should have been done. To answer your question,
I know there are a lot of things that should have been done at a particular time. Sometimes if things are done timely, I don't have a job.
I think at this time it's a no, because we've already been through due diligence. This could have been
Hey, but
discovered.
the
and we're
problem
past
with
that.
that. All right. And everybody just think from a practical standpoint, because I haven't ruled. If the practical reality is that if I grant their motion, you start over and then there's a redemption. And if I don't, then you're stuck, right? I mean,
Correct, Your Honor. And they obtain a substantial windfall, at my client's expense.
no,
I don't
know that that's the case. I
we're
think,
enforcing the contract, if any.
yeah, I mean, people are trying to attribute fault. I don't think that I don't see that case this way. Now, people might be evil on each side. I don't know.
No.
But I don't see that case this way. I don't think anybody was trying to do something fraudulently by filing it in this name. I think that that's just an error in a lot of ways. It's an LLC where the principal owners transfer it back to themselves. It didn't transfer. There wasn't some like bona fide purchaser that did something, or it just isn't that. It happens all the time in this court where I have LLCs or I have partnerships, and the folks that are part of it don't understand that they may be an entity. So these two are their separate entities, but this other thing is an entity in and of itself. So I get all of that. And I don't think anybody's trying to do anything. I don't think that somebody's trying to take a substantial windfall on something that they may not be entitled. But I'm just trying to figure out, before I rule on it, where are the parties on this? Because it seems to me, if your folks want to fulfill the land contract, pay it off, and your folks want to accept it, we can be done.
They've been having that conversation since before I got involved for years, and now I've been involved January. And the same old story, Your Honor. So I think at this point, the plaintiff is fatigued from a time that's elapsed. If the court's inclined to grant any type of relief, we'd ask for cost allowed in the rules. But I also think if there's a creative solution here where, let's say, 30 days is given, we'd ask for some sort of escrow payment or some sort of protection. But it's the plaintiff's request that an order of eviction issue. And if not,
are they going to be able to close over? Are you going to be able to close over the title on the property?
It's the plaintiff's position that title can be conveyed, and the circuit court did not disagree.
That title can be
the plaintiff showcase can show an ability to convey title to Mr. Berlanga, and could have during the redemption period. I think there's more to this loan.
Because I hear you.
Yeah.
I hear you.
All right.
Could have operated, but now I'm here.
Yes.
Right. I hear you.
All right.
Could have operated, but now I'm here.
Yes.
Right. I mean, shoulda, woulda, coulda. But I can't go back. I'm just trying to figure out if there were a solution where within the next 30 days you close on this. Can title be conveyed satisfactorily to defendant in this case?
Upon payment of the total balance, the mortgage can be paid. Yes. Title. Yes.
Right. But
that question is yes.
My issue isn't the payment. I'm assuming there's going to be a transfer of funds. I assume that. What I'm saying is what seems to be the holdup is when they do the title search, the owners of the premises are not showcased. So all I'm asking, whether it be by insurance, whether it be by some affidavit, however it would happen, a transfer back in the register, I don't care how it happens. How are they going to close over that defect?
It's already been done.
What's been done?
It was done on July. It was already done, and it was sent to opposing counsel, and he did not send it.
What was done?
The conveyance back to showcase. Showcase, as it stands, Showcase has title to this property.
Jesus. Are you kidding me?
What?
You've already conveyed it.
The quitclaim deed is attached to our response as Exhibit C.
Yeah, but did that get filed with the registered deed?
And recorded
Okay, so
by the 24th.
And it was recorded on the last day of redemption.
But we could have closed.
Again, Your Honor, their mistake shouldn't be my client's.
Oh, I have to disagree with that because under due diligence,
It's not our obligation to do their
Any
due
buyer
diligence.
or due
We
diligence.
relied on their, Your Honor,
I told you it'd be a good morning. I tried to make it a good morning.
Your Honor,
talking, it's good to have somebody up here that talks.
Your Honor, I agree with you. We always look for a practical solution. In this case, I think the practical solution is to just allow my client to redeem. He was unable to redeem because of their mistake. We're not asking for anything in addition to
So
the
when's
right.
that redemption gonna happen?
Your Honor, at this point, my client has to go back to the lender. They have to go review title again, and they have to review his loan all over. Lenders don't move fast. They do not move fast unless you're working with private lenders.
Hold on a minute. So here's the problem with that. You're right. Some lenders don't move fast, but at the same time, everything, if what you're telling me, and I don't have a reason to dispute it, had been happening toward basically closing, then the only thing that needs to happen is basically the title search. But already part of that's been done.
Your Honor,
So that shouldn't take long at all.
I can't speak for lender requirements, but they're going to reevaluate him based on a new application.
The title search.
Why does there have to be a new? I don't get why there has to be a new application.
I don't control the lender. I'm just asking to make sure that I have sufficient time to go back to the drawing board to allow my client to redeem for the issues that were not caused by my client. That's all. And again, that's the practical solution. I offered it before we came to this court.
Okay.
I offered.
Here's the thing, counsel, and let's be real about this. That comes up during a closing. You could have gotten satisfactory information that the two individuals that owned it really are Showcase, and could have paid an insurance policy to insure over that title defect. You certainly could have done that.
That I don't know a title company that would insure over the.
Oh, absolutely.
Without having a operating agreement from Showcase, without being able to validate the owners of Showcase. I mean, we don't have any information showing who Showcase is, who the members are. This is just brought today. So there's other issues that come to that would come to.
Your Honor, in response.
In closing on property, that happens all the time.
May I respond?
I handle a lot of property.
Go ahead.
Your Honor,
At closing, the title company asked for the Showcase Investments operating agreement, which was disclosed early on. So a lot of this information was available.
He would need to deposit $5,686.50 into escrow. Could he do that?
when would you want that placed into escrow, Your Honor?
Probably even as we're speaking, but when can is that even going to be a possibility?
I can give me an opportunity to discuss with my client.
Was that number 568650?
I have 5686. Okay. But client. Your client's here.
Yes.
Where? Oh, because these two wouldn't move. All right. That was weird. All right. How are you guys doing today? Hold on. You're not usually here, right? Yeah. You?
What?
How come? What time is it?
Your Honor, he said he would
Hold on a second.
request.
10:22. You guys should have late.
Yeah. I did actually go to.
Hold on a moment. We're getting out of this conversation. Really? Okay.
I did.
You showed, is it late?
Yeah,
Or were you
it's-
going to time?
No, like 10 minutes.
10 minutes
Oh,
late.
an hour late.
I get used to it. All right. Okay, anyway, go ahead, gentlemen. What?
Thank you, Your Honor. My client said he would need 7 days to deposit that money.
He hasn't made a payment in 8 months, Your Honor.
Pardon?
He hasn't made a payment in 8 months. Just getting that on the record.
Okay. So that we're clear on where my numbers are coming from. That's basically 3 months.
That's 3 months.
Yeah, so July, August, and if it's adjourned out, I'd be adjourning it out into September. Right. So days out would be okay. Okay, here's what I'm going to do, gentlemen. I'm going to order that the defendant is to post $5,606.50 into court escrow. He's to do that by the 18th of August. That's 7 days from today's date. I would remind you that it needs to be cash to be posted into court escrow. If not posted, then the judgment, the default entered will stand in the redemption period. And I would allow, to the extent it would be necessary, plaintiff to amend their complaint so that the parties are properly reflected if that becomes an issue. But it shouldn't be an issue. So if it's not posted, the judgment stands. If it is posted, then I'm going to extend the redemption period so that it expires. It will expire on September 11th. I'm not doing it that day. I'm going to make it September 14th. Any questions regarding that?
Thank you for your time.
Thank you, Your Honor. Have a great day, guys.
Oh, one last question. Is the court issuing an order? Are you expecting us to come up with one? It's probably worth asking.
No, by the time you guys try to do an order, you're going to be arguing about the order.
Thank you.
So
The court issue.
So, yeah, you can do an order, right?
All right.
Okay, good.
Thank you, Judge.
Do it.
Have a wonderful day.
Have a great
All right.
day.
Here.